The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is per se here to stay? Criminal antitrust cases beyond United States versus Brewbaker. In today's episode, we'll be talking to a former federal prosecutor about the application of the per se standard in criminal antitrust cases. As many listeners already know, a per se antitrust violation is one that requires nothing more than proof that the conduct occurred, with no regard to whether there was harm to competition or potential pro-competitive benefits. The classic examples of cases prosecuted as per se crimes include price fixing and bid rigging among competitors. In an article published in June 2024, our guest writes that a recent appellate opinion by the United States Court of Appeals for the Fourth Circuit may be part of a gradual trend away from the per se standard in criminal cases. In that case, United States versus Brewbaker, the appeals court reversed the bid rigging conviction of an executive, holding that an agreement between competing companies that were also in a vertical relationship as manufacturer and distributor, what we call a dual distribution arrangement, is not per se unlawful. The Supreme Court has just declined to review the Brewbaker decision, so it's good law as of right now. We'll see what our guest has to say about the per se standard and the question posed by her article, Chipping Away at Per Se, is Brewbaker a harbinger or aberration? But before we talk about that, I'd like to welcome my co-host, Brendan Coffman. Hi, Brendan.
Hey, Alicia. Super excited for the episode today. I think we have a really great episode here, and I'm really excited to hear and explain the importance of the Brewbaker case.
Me too. Would you like to introduce our guest and kick off the conversation?
Happy to. Anna O'Brien is co-leader of the Antitrust and Competition Practice Group, Criminal Antitrust and Cartels team at Sheppard, Mullin in Washington, D.C. Before going into private practice in 2020, Ann spent 2 decades as a federal prosecutor and manager at the U.S. Department of Justice in the Antitrust Division and as a special assistant United States attorney in the District for Maryland. She held numerous senior leadership and management positions in the Antitrust Division, including as the assistant chief of 2 sections and as the acting director of criminal enforcement. Welcome to our Curious Amalgam, ma'am.
Thanks for the invite, Brendan. I'm a longtime listener, first-time guest.
Excellent. So just to dive right in, the Supreme Court recently denied cert in the Brewbaker case. Why was the DOJ seeking cert in the first place?
Yeah, this is very fresh, Brendan. And as we're recording this today, and actually it was just yesterday that the Supreme Court denied cert. So the Fourth Circuit, as Alicia described, reversed a bid rigging conviction that many of us in the antitrust world thought was kind of run-of-the-mind bid rigging with a dash of supplier vertical relationship. And so you might think, what is the big deal about this? Well, the Fourth Circuit viewed this somewhat common fact scenario in a bid rigging case as a hybrid vertical horizontal relationship. And even though the DOJ's fraud conviction of Brewbaker was not reversed, so a conviction stood, the DOJ, I think, feared the implications of the Brewbaker decision on the per se shortcut in cases with any type of vertical aspect. So I think they sought cert on the antitrust counts, even though the conviction would have stood. And I think they did that because the per se rule is a bedrock to the DOJ Antitrust Division's criminal program. it really saves them from pleading and proving antitrust harm or effect. And that really we see bogged down non-per se or civil cases. And the DOJ contends vigorously that the agreement is the crime. They need not prove more once they bring a case saying it's a per se case. So I think they picked this one thinking they had good bid rigging facts. And the denial of cert, which I don't think many of us thought was surprising, but the DOJ might have really dodged a bullet with that one, because I wonder if they had, in Supreme Court opinion by, for instance, Justice Gorsuch, if they would have really liked the result in this matter.
Your article mentions United States versus DaVita, in which the presiding judge instructed the jury that it had to find that, quote, the defendant knowingly entered into the conspiracy with the purpose of allocating the market with respect to that conspiracy, end quote. In other words, the agreement to restrain alone is not enough for a conviction. Are Brewbaker and DaVita part of the same trend, or are the decisions separate and distinguishable?
Well, they clearly have different facts, but I think they are part of the same trend. And I think I'll add a little lexicon note here. You know, you called it a per se standard. Even that the parties can't agree upon. Is the per se a standard? Is it a presumption? DOJ doesn't like presumption, but then says it's not so bad in the Brewbaker petition and reply. Is it a framework? I think the parties settled on rule. I call it a shortcut because it is a shortcut. It's a shortcut I benefited from as a prosecutor and that I argue against sometimes as a defense counsel. But I think that is really important in this discussion, because I think that's what we've seen bothering courts. And I don't think this is just the Fourth Circuit. The Fourth Circuit opinion stands now because the Supreme Court has denied cert, but I do think it's a trend. And what bothered the court in DaVita and what we saw in other no-poach cases, like the aerospace Patel case, for instance, in Connecticut, you know, I sat in those courtrooms and I watched these judges struggle with the same thing, which is if the Sherman Act from 1890 says what it says, and it's a very broad statute, then the DOJ says, what I'm putting before you, judge, and ultimately jury, is per se conduct. The defense is precluded from arguing otherwise. And I think we saw judges trying to get that in different ways, the DaVita court grafting in an intent element, and we've seen it in different ways. But it's really at its core some of the same things that the Fourth Circuit was concerned with. I really like, you know, and I will seize on that in the future, that the Fourth Circuit says the Sherman Act doesn't ignore reality. And antitrust law does not turn on artificial mental gymnastics. I think these courts want context, and the per se rule takes away context from the judge and the jury once the DOJ says this is a per se matter and brings it criminally, because they say they'll only bring criminal matters that are per se matters. So there's no determination in their view as to rule of reason. If they bring it, it's per se, and they get a straight shortcut to avoid pleading and proving harm or effect.
So we see in Brewbaker that this is something that arose in the context of a bid rigging indictment. How do you think the trend is going to affect other types of what we all, at least until now, understood to be hardcore per se violations like price fixing, or some of the more modern per se violations, no poaching by employers, and perhaps even information sharing or price fixing by means of AI?
Yeah, I think it's going to have a really big effect, the Brewbaker case. And while the DOJ will try, as they always do when they get stuck with a case they don't like, to distinguish facts, they have backed themselves in, you know, now they don't have the Supreme Court looking at it. And in making a very dire case for cert, you know, they say this is a very common set of facts. It's ubiquitous. It happens all the time. And this isn't really even the most complicated of vertical relationships you see. You see a lot more complicated vertical relationships, for instance, in some of the algorithmic price fixing or information sharing cases where you have different levels, you know, in the chain that are more vertical than even this seems in the Brewbaker case. So I think they're stuck with that. And I think we are going to see a real push for pretrial determinations in criminal cases as to whether the per se or the rule of reason rule or standard applies, because the Fourth Circuit opened the door to that. And they said that a particular restraint is horizontal or vertical. That is a legal issue. It turns on the nature of the restraint, not the overall relationship with the parties. And that's the opposite of what DOJ wanted. That's the opposite of what they argued in the no-poach cases and in novel cases. They don't want that bleeding into their per se criminal cases. And I think we're going to see that litigated pretrial. I think some of the good language in Brewbaker and these other matters is going to bleed into a lot of cases, particularly cases that fall outside the hardcore traditional price fixing, bid rigging, market allocation realms and go further in addressing algorithmic price fixing. If they try to bring many more cases as per se cases, potentially monopolization cases, I think we're going to see this case have real impact, and the DOJ is going to have to be swimming against the current to argue that it's just factually distinguishable and does not apply.
So to answer the question posed by your article, is Brewbaker a harbinger or an aberration? I think I can guess that your answer is that it's a harbinger. It's really part of what is likely to be a larger trend away from that per se shortcut, as you put it. Is that fair to say?
Well, being a true deep lawyer, I'll have to say it's a bit of both. I think, yes, it is a harbinger, but myself and many other former prosecutors, longtime cartel lawyers, you look at the facts in Brewbaker and you say, this is classic bid rigging. So even with aluminum supply, one party supplying another to that, as a division prosecutor, I would have brought this case 10 out of 10 times. And I think really that 9 out of 10 courts would have upheld the conviction, particularly given some of the consciousness of guilt issues. I think factually, aberration. There was some head scratching in the cartel world from that decision. But I think it is a harbinger of future litigation, as I just described, all the things myself and other defense counsel will be raising, because the Fourth Circuit and other courts, they are wanting more. They're wanting more context, that they're wanting to know about the reasonableness. They're wanting to know about the reality, the relationships of the parties. So in that way, it's not just per se, we say, DOJ, we say it's per se, and it's their way or the highway. That's not going to be it in the future. So I think it's a harbinger of some real rough and tumble litigation in the future in the per se realm, where the DOJ has traditionally gotten a lot of deference when they bring a criminal case as a per se case.
Hey, Anne, I want to have the audience get a little bit of the benefit of your experience, because I'm imagining here that you're reading the opinion in Brewbaker and trying to harmonize that with your understanding of what the per se standard or rule was back when you were an enforcer. So I'm hoping maybe you can harken back on your times as an enforcer and compare them to what you're thinking now as you read these cases. Like, do you sense a divide between your understanding of what the per se rule was then and the standard that's being articulated here in Brewbaker?
Yeah, it's a good question that I am thinking about a lot. I mean, in the good old days of cartel enforcement, I was in the old Office of Criminal Enforcement for almost 2 decades. We spent a lot of our time hand-wringing about whether something should be brought criminally. And there is civil per se, obviously, but civil or criminal, per se or not per se, only bringing criminal cases that were hardcore per se cases. And we protected that per se standard as gold. It was our greatest legal asset. And so I think there's current criticism of enforcers of old, like myself, that we weren't aggressive enough. But we didn't break the Sherman Act. We didn't break the per se standard. That was in place, and it was strong, and it was litigated repeatedly. And we brought cases that we thought would withstand that scrutiny. And as you see the Antitrust Division being very aggressive in the areas of labor, no poach cases, trying to call them these traditional categories like market allocation, you're opening up the per se standard and the Sherman Act to litigation. And so I've always said, and there's people say, well, they have to look for more stuff, and this is all cutting edge issues. You can apply the 1890 Sherman Act and the per se standard to all types of different new technologies. But I say per se for horizontal bid rigging, price fixing, and market allocation. And we used to have a rule when I was in the Office of Criminal Enforcement. If all of us were sitting around with the managers of the sections and the case staff, and we had to spend an hour, and I could even shorten that to half an hour, debating about whether something was per se conduct or not, we didn't bring that case criminally because we knew that courts and juries were going to have those same questions. And I think that's the big difference that I'm seeing play out as I'm in private practice.
So obviously, the burden on the government is higher in a criminal action than in a civil action. Do you see what's happened in Brewbaker and maybe just the overall jurisprudence in this space moving in a pro-defendant shift, or is it something more like a satisfactory recalibration against an aggressive government or something else?
I think it's absolutely pro-defendant. I mean, I sat in those no-poach courtrooms and I saw economic evidence coming in that typically wouldn't in a per se case. And now we are able to cite those jury instructions in the no-poach cases, in all cases, because judges have really questioned. So I think it's a pro-defendant shift, just the willingness to look at the context and not just defer to the government's labels. I think courts and ultimately juries want to look beyond those labels and look at context, look at relationships. And that's always a win for the defense. And that's, a big transition coming into private practice is how much you actually learn from the people involved and the business and your internal investigation. And typically in the past, the agreement is the crime and none of that comes in. And the DOJ's lost its foothold there. So I think it's very pro-defendant.
And shifting gears a little bit, there are some who have been arguing that application of a per se rule or per se shortcut to criminal antitrust cases is actually unconstitutional. What is the basis for those arguments, and do you think they're persuasive?
Well, those are arguments as old as time. They're coming up in new contexts, but I know my friend, former DOJ prosecutor Bob Conley, in his Cartel Capers writes about this all the time. It's his bugaboo. And he's been saying that. And defendants have been raising these issues for years and years and years. Mostly, they're unsuccessful. And I think a lot about what the Supreme Court would have done if cert had been granted here. But Brewbaker, in this cert counter petition for cert that never came into pass because the DOJ's petition was not granted, he argued unconstitutionality of the Sherman Act, particularly that the Sherman Act and the per se criminal application unconstitutionally takes the unreasonableness element, which is an element of an antitrust offense, emanating from it has to be a restraint of trade. And in common law, that's been read to be reasonable or an unreasonable restraint of trade per se takes that away from the jury. And that's the core of the argument. It makes different iterations, Fifth Amendment, Sixth Amendment, due process. One we heard a lot was void for vagueness. And when I was a prosecutor, I wasn't too scared of those. I wasn't thinking the 1890 Sherman Act and the per se standards going to topple because of it. And we won. We won really all of those cases for many, many years. But what I think is if the DOJ keeps persisting that burdens should be put on defendants to show that something isn't per se, that's backfiring on them. They've tried to do that in a number of cases. I don't think courts are going for it. The Fourth Circuit didn't say that. The Fourth Circuit even allowed for extrinsic evidence and maybe even a pretrial or certainly a pretrial determination of per se versus rule of reason. So I think, will the Sherman Act be held unconstitutional? I don't think it will. Could the per se standard be narrowed? Yes, it already is being narrowed because Brewbaker identified this hybrid category that falls outside the per se standard. And as we see novel and aggressive applications of the per se standard, I think it could be narrowed even further.
Let's assume, arguendo for a moment that those arguing for the unconstitutionality were successful. What would that mean for the application of the rule of reason? Would it even be workable in the criminal context?
There's two distinct issues here. Is the Sherman Act and its application in all criminal cases unconstitutional. That's the part I'm skeptical will happen. But you're asking about the second part, which is really, I think we're already seeing this happening. So the DOJ, importantly, and I saw in their reply, their cert reply in Brewbaker, they backed off this again. And my article questions whether they stick by this. But they have said, as a matter of department practice and prosecutorial discretion, they only bring criminal cases as per se cases. But I think what judges are dabbling with in DeVita, in the Patel case, in the Fourth Circuit's thinking about is, do we need a pre-trial determination? So DOJ brings the case per se, it's only per se. They say it's per se. We've always seen that in No Poach Defense Counsel. We argued that judges should consider more. They stayed to the four corners of the indictment and said, DOJ says it's per se. They said, but, and this is language I thought was very important, and DOJ blew off, but they have to show that this is an allocation in that context. And I think we're going to see more and more of that. We're going to see pre-trial discussions of whether per se or rule of reason standard applies. And what does DOJ do if rule of reason, the judge finds rule of reason? Do they just dismiss the indictment? I think under their current policy, they're saying they do, but I question whether they're going to argue that, later if they'll change course, because we already are seeing economic evidence that you traditionally have not seen in per se cases coming into criminal cases in the No Poach cases. And we're seeing this. And I think what the judges are doing is figuring out a way to get that context, to learn about the reasonableness and those relationships. And they're doing it through motions in limine, evidentiary rulings that really make these cases look more like rule of reason cases. When you're hearing economic evidence, when you're talking about ancillarity and vertical relationships, is that really a per se case? Even if that label still is on there, if that evidence comes in, I question that. And I think that's the messy, which I love messy, Section 1 issues. I think that's the messy area that criminal enforcement, criminal cases are going to wallow in for quite a long time.
I'll put you on the spot real quick. When you're back at the government, you have a case, the judge says this will not be a per se application, it's rule of reason. Would you dismiss your indictment?
100% dismiss it right away that day. I know when I was working there, I'm not even sure you would need, approvals all the way up the chain to do that, because imagine the mess you are creating. And I saw a little bit of this in a courtroom in Connecticut, an aerospace case, but the mess you are creating, bringing a criminal case to a beyond a reasonable doubt standard before a jury, where you're bringing in reasonableness, economic evidence, potentially ancillarity, extrinsic proof of that, I think it's a hot mess for the division. And I would run out of that courtroom and I would dismiss it, call my boss and ask to dismiss it within the hour. And I think a judge would expect that, actually, given what, the DOJ was pushed on this in some of those motions in limine and the No Poach cases, and they waffled a little bit, but now they've said it in briefs. And so for a 180 switch of the Department of Justice on that policy is a big deal.
Thank you, Brendan, and thank you, Anne. Before we end this episode, however, I want to mention to listeners that we'll be posting useful links on the episode webpage, including the Fourth Circuit's Brewbaker decision itself. I think we'll post the government's writ of certiorari, even though we know it's been declined. I think it'll be useful to look at those arguments, and we may come up with some other goodies for you as well. So, Anne, now is the portion of our episode where we like to get to know our guests a little bit better as people. Let's start with the following. Can you tell us something interesting or unusual about yourself that is completely outside of your professional life?
Yes, I can share with you something I've shared on LinkedIn and with people through a lot of great thought. And I wish I was not interesting in this way, but I am a survivor of a rare ovarian cancer called a granulosa cell tumor that went undetected for a very long time. So I like to talk about that. I am great. I am doing great now. And I view it as a source of strength, not something I thought about for a long time about sharing that. But I think that I am an advocate for a living. I am married to the most 100% supportive advocate I could possibly have. I have all the resources. And I went undetected with a rare cancer for a long time, even though I knew something was wrong. So I share that to hopefully, one, tell other people, if you think something's wrong with your health, go advocate for it. And two, All of us lawyers have deep stories that none of us know. And I think many of them, not just health challenges, but make us stronger. And we should take time to really appreciate that about each other. So someone did once tell me that cancer made me more interesting. My response was, I would have taken uninteresting. But since you asked, I'll leave you with that.
Yeah, well, that's great. And you're helping to build some awareness even right now. So thank you for that. And finally, the last thing we'll do is play a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game are extremely simple. Brendan is going to pull a random question out of an entirely virtual hat. So take it away, Brendan.
All right, Anne, if you were offered a seat on the next space shuttle, would you accept it or not, and why?
Oh my gosh, this is a great question for me. I would not, but if allowed, I would absolutely beg to give it to my husband, Paul O'Brien, of ICN, FTC fame. Many of you may know him, the listeners, because that man loves space. He went to space camp. He went to Space Academy 1, Academy 2. He would love it. So I would say no. I have no real interest in that. I don't even love flying, even though I do it a lot. But I would beg for my husband to be able to go because he has been training for that his whole life. And thank you for that question. I couldn't have expected a more fun question for the O'Brien family except space. So thank you.
Well, what do you think of the two astronauts who've been stranded up at the space station now for so many months?
That's my nightmare, Alicia.
Yeah.
That's why I would not want to go. I think it would be cool for a few minutes, but certainly not for that long.
Well, I can understand that. Thanks again, Anne, and thank you, Brendan. Thank you to listeners. Everybody tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.